Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. This week, the Supreme Court heard oral arguments in 4 cases. Plus, the Supreme Court issued its first 4 opinions of this term. In today's episode, we deliver thoughts on these oral arguments. We also released breakdowns of the 4 opinions. We release these breakdowns as 4 separate episodes. Check out these episode breakdowns to learn about the opinions. Now, I wrote the scripts, but I used AI text-to-speech software because I didn't have the time to read all the scripts. Now, before we recap the oral arguments, here's my reminder to please follow, rate, subscribe, share, and review the podcast. Also, follow us on LinkedIn to get rundowns of the opinions and to communicate with us. Just search the High Court Report. And if you have any questions or comments, you can reach out via LinkedIn. And if you have any questions or comments, reach out via LinkedIn or email. Our email address is scotus.cases.pod@gmail.com. And I'd like to go in order of oral argument. So let's start with Chevron v. Plaquemines. And for this case, I want to begin with the why this case matters. After all, Plaquemines will get their day in court. It's simply a matter of federal court or Louisiana state courts. The justices posed this very question to both sides. Chevron's counsel, Paul Clement, answered by invoking Daniel Webster's commentary from 1812 to convey that federal courts protect nationally important projects from local bias and prejudice. Mr. Clement also underscored that federal courts offer better appeal options. He specifically mentioned how federal courts give an avenue to appeal decisions while litigation is ongoing to courts of appeals and even to the Supreme Court. That way, the person appealing can get a ruling in their favor before having to go through an entire trial. Mr. Clement also admitted that his clients fear a massive verdict against them. And for good reason. In another case involving this issue of World War II oil production and dumping in Louisiana, or their parishes secured a $744 million judgment. Chevron doesn't want that. On the flip side, Mr. Aganaga argued for Plaquemines Parish that state judges serve as the true experts on local laws. He said that the Louisiana Supreme Court should decide the meaning of this massive issue because it involves Louisiana laws. His position boils down to this: Louisiana state judges know Louisiana laws best. They should be the ones to decide this case. Now, aside from the why, the debate in this case centered primarily on the words relating to. Drawing on other Supreme Court opinions, Chevron argued these words relating to read broadly to encompass many operations, even if not explicitly tied to contracts. They believed that conduct satisfies this relating to standard if the conduct at issue will have a direct negative effect on the government's contracting goals. Several justices, including Chief Justice Roberts and Justice Sotomayor, questioned whether this test swept too broadly. Chief Justice Roberts expressed concern about a butterfly effect. A broad rule might allow every federal contractor to escape state court. For example, and this is my example, if a company sells paper clips to the Pentagon, does a lawsuit against that company regarding their paperclip factory belong in federal court? Even if the company also produces paperclips for people and private corporations, let's say their paperclips are sold at Staples. That was an issue that the justices explored repeatedly. Some justices posited a narrower theory, which is called a but-for test. Some justices posited a narrower but-for test theory. Now, Plaquemines didn't really contest the words relating to or the fact that those words generally speak broadly, but they argued that the conduct sued over must relate to the work for the government. The work must relate to the contract. Plaquemines argued that under any test, but for or relating to, Plaquemines wins because the conduct charged, oil production and dumping, didn't match what the contract required. Now, both sides made some pretty compelling points, but I predict a victory for Chevron, or at least a decision that vacates the lower court rulings and sends them back for additional analysis. Most justices did not like the test that the Fifth Circuit adopted. Even Mr. Aguinaga conceded that the Fifth Circuit test did not follow the statutory text at issue here. So I can see the justices kicking the case back to the Fifth Circuit or the district court with instructions to apply a different test without deciding whether the conduct here actually amounted to legitimate grounds for removal into federal court. All right, let's move on to the Title IX transgender tornado cases. Little v. Hecox and West Virginia v. BPJ. These parallel, not consolidated cases went exactly as predicted. A majority of the justices seemed disinclined to draw constitutional lines to protect transgender people. A majority also seemed reluctant to wade into the debate about transgender rights, especially when some states, such as California, recently passed legislation that permits transgender people to participate in women's sports, the opposite of the laws in Idaho and West Virginia. Also, as I mentioned in my episode on Monday, on the heels of Scrimeti, which recognized broad state authority affecting transgender people, there's just no way the court curtails this authority. I predict a majority of the justices will rule in favor of Idaho and West Virginia. What I found most interesting was the United States government's position. Mr. Mupon, representing the United States from the Solicitor General's office, argued forcefully that states can impose biological sex differences for athletes. But the justices teased out how the United States is actually challenging California's law by arguing California cannot permit transgender students to play sports with their gender identity alignment. The justices wanted to know how the United States could credibly make seemingly contradictory arguments over the same issue. This will be the next frontier for transgender rights. This frontier will be the legitimacy of state laws that protect transgender status, especially when it comes to athletics and other similar areas. Finally, let's discuss CSX Gillette v. New Jersey Transit Corp. And New Jersey Transit Corp. v. Colt. The court seemed especially concerned about the question of formality versus functionality. What do I mean by this? Gillette and Colt argued that New Jersey's formal choice to create a corporation carried heavy legal consequences. They claim the state used this corporate label to bypass debt limits and distance itself from the agency's financial liabilities. And distance itself from the transit authority's financial liabilities. Transit countered with a functional argument, arguing that transit can issue regulations like a state agency can. It also holds criminal enforcement power, meaning it can force criminal laws in New Jersey, just like the state police departments can. And it can exercise eminent domain, which is historically a state feature. According to transit, these are classic hallmarks of a state agency, not an independent body. Justice Kavanaugh and others honed in on the risk of chaos argument. Many states created transit authorities and other state functions using the vehicle here. For example, some states created state-run hospitals, but they call them instrumentalities, and they have similar setups as the transit authority here. These hospitals can sue and be sued. They can buy and sell land. They may even have some sort of criminal enforcement authority, things like that. The justices, including Justice Kavanaugh, seemed concerned that upending this setup would jeopardize the status of these state corporations nationwide. I predict transit will win. Case law in this area centers on the degree of state control and the party in interest. Here, New Jersey retains control over transit. Here, I think the court will say New Jersey retains control over transit, even though the statute says New Jersey isn't liable for transit's debts. In practicality, New Jersey routinely covers budget shortfalls for transit, sometimes up to $200 million in a given fiscal year or more. They also appoint board members. New Jersey also appoints board members and actually owns transit. Transit doesn't own any property. All of the property within Transit's authority is owned by New Jersey. And functionally, as Chief Justice Roberts drove at, New Jersey would be on the hook for liabilities transit can't cover. I also think the risk of chaos will emerge as a factor for the reasons I just said. Many states created these types of corporations to fulfill similar public utilitarian functions. And so ruling that these functions no longer satisfy sovereign immunity will create a sea change across the 50 states. Plus, the conservative justices probably won't depart from a 1980s D.C. Circuit case written by Judge Bork and joined by Justices Scalia and Wright. Yes, that Judge Bork from the Nixon era. The D.C. Circuit case ruled in favor of sovereign immunity. Justice Alito and Justice Kavanaugh in particular seemed unwilling to go against the fundamental analysis that Judge Bork and then Judge Scalia advocated for. Those are a few of the nuggets I gleaned from oral arguments. What did you take away? Do you agree or disagree with my predictions? Let me know. That's it for today's episode. Thanks for listening. Remember, please follow, rate, subscribe, share, and review the podcast. Follow us on LinkedIn to read rundowns. Just search the High Court Report. And again, if you have any questions about this case, reach out via LinkedIn or email. Next week, the Supreme Court will hear two major cases. One, a Second Amendment case, and two, a Fed firing case. And two, a Fed firing case. Check out my case previews and mega episode for additional details on these cases. Talk to you soon.